Welcome back. With us now is Jason Nowlin. We're talking about divorce odds and ends. Jason, before the break, we were talking about temporary alimony and support and temporary custody matters, and I think there's a few items you wanted to address with temporary alimony.
Correct. I thought to tie up the loose ends on that particular subject, child support is a calculation that's set by a calculator. It's sort of an algebraic method of determining it. There's not really much you can do to alter it. Temporary alimony, however, is based upon the need of the spouse who's requesting it and the ability to pay of the person you're requesting it from. So at the temporary hearing, the divorce referee, and again, if there's a rehearing on it, the judge looks at an affidavit of income and expenses filed by each party, hears proof and testimony from the parties, and determines whether the person who is being requested to pay it can financially afford to pay it, and whether the person who's requesting it has a real need for the amount that's being requested. And it's very discretionary with the court, whatever amount they order. It's not a formulaic type of equation that comes up with this number. But I think that basically glosses over at least the issues pertaining to temporary support and custody. And one other item I know that you and I have discussed that comes up oftentimes post-divorce, can come up during the divorce, is when a party wants to move once there's a custody order in place. And there's a specific statute dealing with relocation. I'm not going to get into the great detail of it. I think it's beyond the scope of our time here today. Mm-hmm. But I will say that basically if you're looking at a relocation situation, what's very determinative of the outcome of it is what sort of actual parenting schedule is being followed. You can have a parenting plan that provides whatever it provides. It may say that, mom has the children 2/3 of the time. But when the court looks at a relocation, the court looks at what the parties have actually been doing immediately preceding the filing of a request for a relocation. And so, again, it's what really impacts that decision is whether the parties are spending substantially equal amounts of time with the children or whether one party has substantially more time than the other. I think it's probably logical to most people listening that when the parties are spending closer to equal time, substantially equal is what the statute says, then the burden upon the party who wants to move away with the child is much greater. Obviously, the child has there's much more chance that the child has a closer bonded relationship with someone they're spending substantially equal amounts of time to, as opposed to maybe a parent they see once a month or something. Mm-hmm. Under that situation, the legislature has chosen to see fit that they make it a little bit easier on the person who's attempting to relocate, since they're spending the majority of the time with the child. And in that circumstance, it's not nearly as complicated of a decision for the court to make. If there's a party who has the majority of the time with the child, and this isn't exactly the language of the statute, but in essence, and if you have to show that they're attempting to move away to deprive you of time with the child, to be vindictive, that their attempt to relocate doesn't have a reasonable purpose. Mm-hmm. However, if the parties are spending substantially equal amounts of time, there's a much greater level of scrutiny placed upon that decision, and the court's going to examine what's in the child's best interest to determine whether you can relocate.
Okay. Yeah, and it's a complicated situation and everything. So to give people a real-world example, I guess, on the temporary support hearings and custody, I'll give you a quick fact scenario, and we're only going to have probably a minute after I run through the fact scenario. But being a feminist, we've got the CEO of a medical device company is Sally Smith. And she married John Smith, and John Smith gave up his career 10 years ago when they had children, and he's been the primary caregiver in the home of those children while Sally's been out there gangbusters making it to CEO of the medical device company. Well, they wind up, irreconcilable differences occur, and they file a divorce. Well, they've got two children that are 12 and 13, and John doesn't have the ability to just go out and get a paycheck that is comparable to the lifestyle that's been lived to provide for the kids. How does that break down as far as if he goes in and asks for temporary support, how would that be viewed?
Well, I mean, you're kind of hitting oftentimes what people think of as the exact opposite of the quintessential situation, but we have all different types of families and situations nowadays, obviously. It shouldn't be treated any different than it would be in the inverse situation. Basically, if the father is the children are residing with him the majority of the time, then he has a right to petition for child support, temporary child support, and that's going to be based on actual income that goes into the child support calculator that we discussed earlier, and the number of days that the parents spend with the children impact the amount of support. If you spend more time with the child, you pay less child support. It's kind of logical. Also, what goes into that determination is who's paying health insurance. That gets factored in and is credited to the party who's paying it as a form of child support they're paying. And also work-related child care is credited to the party who's paying it. So once you determine those factors, unless there's, with some exceptions for deviations that are built into the statute, generally that's what determines child support, plugging in these figures, plugging in these numbers. However, in the scenario that you gave me as to temporary support, well, again, I believe you said his name was John. John's going to file an affidavit of income and expenses that lists all sources of income he has, list out all of his expenses, and more than likely he's going to have a shortfall at the end of the month, a deficit that he's coming up short every month. And if the spouse, the female you've discussed, if she's going to fill out an affidavit of income and expenses, presumably with her greater income, she's going to have a surplus at the end of the month. And based upon those numbers and the arguments and the testimony of the parties, the court determines what amount the obligor spouse, the one who's being requested to pay alimony, can afford to pay, and what reasonable needs John, in this instance, has, and how much has to be paid to him every month to sustain, a reasonable lifestyle. Now, you can't expect the same lifestyle that the parties had prior to their separation. But
and unfortunately, we're out of time. So our time's up for this edition of Legalese. I would like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you'd like more information about Legalese or any other program on GHS TV, please refer to our website at www.ghstv.org. You can also follow us on Facebook and Twitter. Thank you for joining us today, and be sure to join us next month for more discussion on legal topics. Until then, I'm Vince Perryman. Thank you for watching.